Hey, folks, just as the title says, this is why you need to sell real estate early in the probate process. Understand that the probate process can be tired, messy, icky, disgusting, ew. But the thing about it is that real estate changes in value. However, if a piece of real estate ever gets caught up in the probate process where it never gets sold and it never gets, well, inhabited, then generally what happens is it falls out of maintenance. And sometimes the house just falls in, or squatters go in and destroy the place, or any number of things. It could be somebody stealing the personal property in it, squatters. House burns down because of squatters. It doesn't have any power or electric or anything else like that. But there's a couple of reasons why you need to sell it early in the process. And I'm not trying to fearmonger anybody, but let's fearmonger. First of all, the financial benefits from your particular situation is going to come in a lot better than if, say, for instance, you let the property go on for an X amount of time. And what I mean by that is that the longer that it sits there, the longer it has the opportunity to get either beaten up, squatters, destroyed, stolen, broken windows, etc. So it helps you mitigate a lot of that before it even happens. And a lot of times people don't think that it happens when they say, well, I want this, I want that. But by the time the courts roll around and say, okay, sell it, all of that's happened. So the $300,000 house that you have generally has to be bulldozed, or it has to be completely revitalized in order to do it. So when you go to sell it, instead of you getting $350,000, you may get $100,000, and because the people who buy it are going to have to go in and completely revitalize it. It also gets rid of the mortgage payments, not only the mortgage payments, but the tax payments, water, sewer, all of that. If you sell it early in the process, it gets rid of all of that. So the uh, estate doesn't have to worry about that, and the executor doesn't get gray hair. The expenses can add up, and it might even burden the estate, getting to the point where the money from the estate and the personal property sales has to go to pay for all of that. And that's not helping anybody, especially if you've got beneficiaries that are actually thinking that they're going to get some money, and then they find out that they have to pay money into the estate in order to settle the real estate issue. Now, understand, not all real estate goes through probate. We understand that, we know it. However, there's a good chance that even if it is a welfare type of thing, not welfare, Medicaid, Medicare type of lien, if you sell the property, you're going to get the maximum amount of value back to pay off those liens. A lot of people think, well, you know what? I think we're just going to go ahead and let that lien ride for 10 years. But Medicaid doesn't work like a credit card type of system. That lien is on your deed, which will stay with the property until it's transferred. And Medicaid has to give that little check mark saying that we're going to allow it to process, go forward, move forward, and it's going to ensure that they're going to get their money back one way or another. Now, if you let it sit there for 10 years and you sell it for 50% of the value of it, the estate is still on the hook for the other 50% of the value, unless you have a pretty darn good lawyer who can talk them out of the other 50%. Not only that, but if you sell it earlier on in the process, even if it is inside of the estate or outside the estate. And what I mean by that is if it's inside the estate, it has to be sold in order to pay off the debts of anything that's inside the estate, such as medical bills, etc. If it's outside the estate, then the beneficiaries, or the heirs in this case, can sell it and divide the proceeds. However, the thing about it is, if you have one person who's being ornery, again, you're going to have the same as previous, is where you may have $400,000 and there's three of you. Well, you have that one person who screams and hollers and says that it's worth $650,000 when there's nothing that evidentiary that proves beyond a reasonable doubt that is. And it'll sit there for God knows how long until it finally gets sold. And usually those are the properties that sit there until they're abandoned or burned down, like the one that happened across the street here. Selling the property can expedite distribution of the money and the assets and everything else, and get it technically close it a lot sooner. As soon as you have somebody who sues the estate for any particular reason, you just created a 10-year problem. Doesn't matter if it's for $1 or $100,000. It creates a 10-year problem. Once the property is sold, the proceeds can be distributed among the rightful heirs according to the will or the state laws. Now, understand that if they die without a will, that's called intestate, which means that the state will go and find anybody who is a particular quote unquote heir to that particular piece of property. So, say for instance, Tommy over here is the son of George, and George had a sister named Susan, and Susan has a daughter named Myra. Okay, well, guess who gets a split? Myra and Tommy. That's what the state does, because what they do is they split it up. Heir number one, heir number two, heir number two passes away, who's below that? And they will go down until they find the last piece of DNA in the system that gives them the authority to transfer that information or transfer those assets. So it's important that you die testate, which is with a will, whereas your assets know where they're going to go, at what time they're going to go. My kid is getting ready to go into the Army, and I told him, before you leave, have your will. And he goes, well, I don't have any assets. Doesn't matter. You've got bank accounts, you've got a truck, you've got all this other stuff. You need to say where all of that goes before you walk out that door and get on the bus to go to basic training. So you have to understand that you want to avoid any kind of depreciation when it comes to the assets. So it's important to sell it as soon as you get your letters of testamentary, or you get sworn in as the administrator or the commissioner for this particular piece of property. You want to minimize the complications too. Properties in probate can sometimes lead to disputes among heirs or beneficiaries. And I can tell you, real estate is one of the largest pieces of disputes amongst the heirs, because sometimes people carry on a 25-year grudge that they didn't get enough oatmeal when they were a kid. And sometimes it's just they don't feel like they've ever been treated fairly and whatnot. That into account, the state doesn't care. The probate process doesn't care. Their job is to look at what is there and then split it evenly amongst everybody. So if you don't think that your sister over there should get a share, and you think that you're going to wait her out until she passes away, well, I hate to tell you this, but regardless of what you think and what you don't think, the state is going to give it to their children, give it to her children or their children. So it doesn't matter. It's better to do it now when the value of the property is high than try to sell it when it's all falling apart. It's been burned, it's been destroyed. It has several years of back taxes that hasn't been paid that you have to make up before you do anything with it. So it's important to understand that the complications that you throw into it cost you money. If you sue your executor, it's going to cost you, and it's going to cost them, and it's going to cost the estate money, a lot of money. Probate's not cheap. You think that throwing one of these things, a lawsuit at one, just because you think that you're due more money than anybody else, well, you just threw a major expense into the estate budget, which is, instead of getting $140,000, you may get 10. No, I don't mean $10. I mean you may get 10,000 of that $140,000 because probate is expensive. Lawsuits are expensive. And if you think the executors are going to work for minimum wage just because you think that you need to get another dollar, you just lost that dollar plus. So you want to ensure that you have the estate for sale as soon as you get clearance so you can minimize those kinds of complications. Once those complications pop their head up, you lose value. And when you lose the value, then you get more complaints because it's like you coulda, woulda, shoulda. And the same people who are saying you coulda, woulda, shoulda are the people who turned around and stopped the process in its tracks because they coulda, woulda, shoulda understood. And sometimes it's not the individual, but it's the attorneys that don't understand what's going on. And they don't ask the questions. They just say, well, according to the will, this, that, and the other, well, we're going to sue you. The whole purpose behind the attorneys is that they're going to milk it. And I don't want to say that as in, anything negative. They're going to milk it to the last dollar. And then what they do is they'll sit there and they'll sue the executor, saying that they have attempted to fulfill themselves financially from the estate. Well, what do you think the attorneys are doing? Suing you for 33% plus whatever they get, plus their retainer. Really? I'm unjustly fulfilling myself financially from a transaction. However, you're taking almost 50% of it right off the top. Yeah, I think that, ladies and gentlemen, rethink what attorney that you're talking to. Because some attorneys have no idea what's going on as far as the probate space, even though they say they are estate attorneys. And what I mean by that is, if you die intestate, which is no will, and you have 4 daughters, all 4 of those daughters get one piece of the pie. So they get a 25% interest in all the real estate. Well, some attorneys are like, well, why didn't you sell it? Well, when it is in that particular position where it's not inside the estate, but it is tenants in common like that, it takes all 4 signatures. And if one person decides that they don't want to and they want to sue, sometimes the amount of money that they use to justify the lawsuit, if they would have sold the house, they would have gotten the $350,000. But when they turn around and sue, it will commonly take $350,000 for the lawsuit. So you, as a feeling human being, have to understand that lawsuits aren't cheap, your attorneys aren't cheap, and sometimes your attorneys will say that they are estate attorneys and they don't have a clue about estates. So let's talk about the legal and administrative efficiency of selling your property early. Completing the sale early can streamline the probate process, such as that money can be distributed. If it's inside, that money can be distributed inside the estate. If it has to go to pay a Medicaid or a Medicare lien or any other kind of lien, that money can go ahead and get paid. Your executor can go ahead and cut those checks. And it reduces the administrative burden and allows the executor to focus on other aspects of the estate settlement, such as if there's any kind of IRAs, 401ks, lawsuit settlements, or anything like that, to which they can turn around and they can go ahead and focus on those things and getting that paperwork handled versus having to deal with the real estate. Additionally, a lot of people will say that they disagree with selling the real estate so early. But like I said before, you have holding costs such as taxes, power, water, and all of those other considerations. And when the taxes get to the point where all of a sudden the money from the estate now has gone to pay the taxes, both local and county taxes, now you don't have anything to distribute. So you're basically shooting yourself in the foot if you don't get early enough in the process. Uh, and it's really up to the executor if it's inside or outside the process. But if it is inside the process, then you have to get the clerk of court to nod and say, okay, sell it. Additionally, it's crucial to consider various factors, including the market conditions, the state of the property, potential tax implications, and preferences to heirs and beneficiaries. Sometimes holding on to the property for a small amount of time might be beneficial if it's expected to appreciate significantly, or if there's specific wishes outlined in the will regarding the property. Now, uh, understand there's nothing that says that you cannot rent the property while it is in some kind of debate. You want to have some kind of income producing property and something that's being maintained versus, uh, just letting it sit there empty because you don't want to sell it in a down market. And then what happens is somebody kicks in the back door, steals everything inside the house, plus the handguns and everything else that's there, the silver and whatnot. And then they leave the house wrecked and it fills up with mold, mildew, and you can't do anything with it. So you want to talk to a real estate professional before you do anything as far as just leaving it there, especially if it's in a high area where you may have people coming in and out on a regular basis and you don't know who they are, where they're coming from. So anyway, folks, you want to make sure that with what you have, you keep safe, and what anything else happens, you're able to maximize your return on the real estate as it is now. Right now, as it is, if you do not have a house that's in probate up for sale, then it's a big mistake because this is a seller's market. Waiting for it to turn around when it's a buyer's market is going to adversely affect you, and it's going to lower the value that the estate gets. So, that being said, I am Matt Price. I'm your real estate broker and your auctioneer. Give me a call, 919-614-6288. I'll be happy to help you any way that I can. Have a great week.